I'm going to talk about 4 things, if I may, in the 20 minutes available to me. First, I just want to talk broadly about the perspective of judges actually dealing with these cases. Secondly, a little bit about the evidence flowing on what from Norman Manoyam has said. Thirdly, a couple of technical arguments. And finally, try to deal with the question of criminal activity, the question which was already posed. As David Untold has correctly observed, there's probably not a competition authority anywhere in the world, with all the economic debates that we have about what the purpose of competition law should be, whether one takes an extraordinarily narrow view, such as the contemporary American scene, or broader views, such as the erstwhile European approach. The one thing we're all agreed upon is that cartels are the most pernicious form of anti-competitive activity. Our Supreme Court of Appeal, in a case I'll come back to, said a few years ago, price fixing is inimical to economic competition and has no place in a sound economy. Adopting the language of the United States antitrust law, price fixing is anti-competitive per se. All countries with law protecting economic competition prohibit the practice without more. The fact that price fixing has occurred is by itself sufficient to brand it incapable of redemption. Now, why I mention this is because I think it's important to understand, and I'm being asked to talk from the perspective of a judge and someone who's been sitting on our competition appeal court now for more than 16 years, is when a judge gets a case dealing with cartels, like any other case, it defines the approach that the judge is going to take, at least prima facie, to the dispute in hand. In short, unless the judge is a complete ignoramus who doesn't really worry about anything that happens anywhere in the world, and I suppose you're going to say that's an assumption you're not prepared to just reject out of hand, then it becomes perfectly clear that there are defining characteristics. Take the World Bank study. I was going to talk a bit more about that, but Tembi has done that for me. So just let me recap a couple of things. The World Bank study, which looked at the South African situation, found that the disposable income of people increased by 1.6% as a result of the extraordinary successes that the South African Competition Commission had with regard to cartels. The study finds that 15% of the goods in the consumption basket of poor people, as they defined them, were represented in the kind of activity that the Commission was dealing with, that is wheat, maize, poultry, pharmaceutical products, for example. Now, what I'm simply suggesting to you is when a court gets a competition case and is aware that it's a cartel and is aware that it's dealing with wheat or maize or poultry or any other area that affects poor people, in a country like my own, South Africa, where shamefully we still have the highest Gini coefficient in the world, which measures inequality, it stands to good reason that the judge's first move is to say, you're going to have to persuade me long and hard here that in fact this isn't a cartel and I can go and sleep peacefully at night. There is a defining kind of adjudicative framework which in a sense shapes, I think, the process by which a judge looks at these cases. In short, judges are not oblivious to the particular social problems which in a sense are thrown up by cartels and which are so luminously illustrated by the World Bank study. So that's just the first point. Secondly, the question of evidence. I cannot emphasize sufficiently the importance of what both Tembi and Norman have said with regard to the question of leniency programs. Take the alternative approach. If you look, for example, mentioned as the name, Professor Joseph Harrington from the Wharton School of Business, strangely enough, a very leading school of business, although I suppose some of us have a different view on it now that Donald Trump claims to have gone there. although apparently in all due accuracy he only went there for 1 year because he actually went to Fordham, but then Mr. Trump and the truth are strangers and haven't met for years. But that's another matter. If you look at Professor Harrington's work, the approach to say, let's try to use economic modelling to detect whether there is a cartel, to look at the nature of prices in the market, and to create one or other model or alternative investigation of the structural conditions of the market in question, to make a determination as to whether there's a cartel, is enormously tricky. Enormously tricky. I've taught that material for some years on my competition course, and all I can say is that if you're going to put that into a judicial framework, into a trial framework, it's very, very hard to see how, in fact, that kind of modelling is going to be sufficiently persuasive on a balance of probabilities for a plaintiff, that is, for the authority to come home. So the question of acquiring evidence unquestionably has become more and more prevalent through leniency and similar programs. In my own view, listening to your problems in Namibia, and it's far from a South African to offer advice to another country which one has only been to a few times in one's life, although one is not American who does that all the time. In my context, all I can say is I wonder whether the real approach is not to actually just formulate a leniency program and allow one of these cartel people to take it to court and say that it is in fact invalid. Again, bearing in mind my framing of what cartels are like, it may well be that judges are very unsympathetic to the idea that, in fact, leniency programs shouldn't be operative, particularly because of the enormous amount of redistributive consequences that they affect. Thirdly, let me talk a little bit about the technical arguments that I wanted to mention. The South African Act, if you look at Section 4.1b of the South African Act and compare it to Section 23 of your Act, which we've already seen very clearly presented earlier this morning, the difference is that you borrowed, it seems to me, Article 101, as it now is called, from the EU, and effectively, as David Windhoek has suggested, might have got a better framing than we did. There's a real debate about this. Let me explain. The South African argument was, in effect, that we wanted to say, a la the US, that certain forms of activity were per se prohibited, that you didn't want to have arguments about substantial lessening of competition. And the reason you don't want that is particularly because judges as a whole really are not particularly well versed in matters of economics or the evaluation of economic evidence. Now here, of course, it goes to the High Court, which means you don't have a specialist tribunal. Even in my own country, where we've got a specialist competition appeal court, the critics, including people to my right here, have often argued that actually we are only specialists nominally, because what we were smoking when we came to actually the judgment that we did come to reveals our ignorance in the most clearest of fashions. But the point about it was that when you're a developing country, there is an argument to be said that you want to cut off the idea of economic evidence and make it as easy as possible for the authority to come home. There's a debate about that. David Windhoek has quite rightly suggested that one of the problems with that is in how do you distinguish between forms of, let's say, pricing which may not well be cartels, such as a joint venture, and a hardcore cartel. And that's created its own difficulties in the South African context. We, early on in our jurisprudential journey, we came across a case called Anzac versus Botash. This case was illuminating for a number of reasons. Firstly, it was a case dealing with a Delaware corporation which essentially combined a series of soda ash producers in the United States of America, which if they were selling in the United States of America would have breached Section 1 of the Sherman Act. But in eloquent illustration of American imperialistic hypocrisy, they have a thing called the Webb-Pomerene Act, which means that they can have export cartels. That means that they legislate to allow that which they themselves prohibit domestically, but from an export point of view, it's fine. Right? And that was what ANZAC were. And not only was that a problem, but ANZAC's lawyers were extraordinarily imaginative. My own view was that I thought, and we started this case up shortly after I became a judge, on the judge president of the Competition Appeal Court, I thought I'd retire, long been retired, and the case would have still gone on. Because that's the problem with deep pockets and large cartels and litigation, is that we can carry on taking technical argument after technical argument. But the problem in this case, which then was created, was this, that the court then decided that they needed to introduce a categorization issue. That is, they looked at American law, and if you looked at Section 1 of the Sherman Act, it just basically says that if you fix, boom, that's it, you are guilty. And so they said, well, now we've got to allow evidence to suggest, to find out whether the particular conduct which is alleged is really price fixing or not, which in turn creates a really havoc of a problem, which means that when you get these cases, is it then a per se prohibition? Or do you then sort of have to have certain preliminary evidence to determine what kind of category of case you're talking about, and then only do you kind of fall within 4.1b? So I'm not sure that you haven't got a better deal with the Section 23. And that in a sense means, to a large degree, that the section that you choose actually has a very significant effect on the way the court goes about the business. I could go on and on about ANZAC Potash, but I'm merely giving you an illustrative argument. The next technical issue, which I just want to deal on briefly, is this issue, and this is really most important, about the agreement or the concerted practice. Your definitions are basically the same as ours, and I'm not going to waste time on the small hermeneutic differences between the two. What I do want to say is this. One of the problems that you've got, even when you have evidence with regard to the fact that these parties have actually met, these parties have actually had discussions, is you get the situation that a party says, well, there's no consensus. There's no consensus. We never agreed on anything. Those of you as old as I, there must be just a couple in the room who may once upon a time have also seen the wonderful BBC series called Faulty Towers, will know that there was a character in Faulty Towers called Manuel. And Manuel always used to say to Basil Fawlty, I know nothing, Mr. Fawlty. And that's what cartel people do. They say, we went to the meeting, but we know nothing. Well, what were you doing there? No, it was very useful to come to the meeting in order to see what our competitors were doing. Who wouldn't go to a meeting to find out what competitors are doing? But did you agree with them? No, never. We never said anything. Nothing. We know nothing. Right? Well, the problem is, as a court, then how do you sort of translate a participation in a meeting, or at least attendance thereto, or alternatively, some other form of implicit conduct of a similar kind, to convert into an agreement? Now, of course, in our law, we've decided, and it's quite clear from our definition, that agreement doesn't mean a legal contract. That our courts have basically said, pursuant to the definition, it's a contract arrangement or understanding. And it is also true that consistently what that has meant, as the tribunal has found, that a positive meeting of minds, as is understood in the law of contract, is not required. The tribunal has found that actions which could allow a firm to rely on the agreement of another would suffice for purposes of competition law, noting that contract law is concerned with the private consequences of agreement, competition law with the public consequences. And so when it goes on to say it's sufficient if a firm intended to contribute by its own conduct to the common objective pursued by all the participants, and that it was aware of the actual conduct planned or put into effect by other undertakings or firms in pursuit of the same objectives, or could reasonably have been foreseen this, and they was prepared to take the risk, that suffices. I think that's quite right. Now, the question then arises for a judge, what duty is imposed upon the party who says, I knew nothing, or I knew something, but I didn't do anything about it? European law, in a sense, is instructive in this regard. So in a series of cases, they have said that it's sufficient for the Competition Commission, the European Commission, to show that the undertaking concerned participated in meetings at which anti-competitive agreements were concluded without manifestly opposing them, to prove to the requisite standard that the undertaking participated in the cartel. Where participation in the meetings has been established, it's for that undertaking to put forward evidence to establish that its participation was without any anti-competitive intent, by demonstrating that it had indicated to its competitors that it was participating in these meetings in a spirit that was clearly different from theirs. And the court then went on to say that the reason underlining that principle in law is that having participated in the meeting without publicly distancing himself from what was discussed, the undertaking has given the other participants reason to believe that they were complying. And one of our big challenges then is how, in fact, we impose a duty to speak, that is, on the particular participant. Because even with a leniency agreement, even with that level of evidence, this becomes a huge challenge for courts, because that's generally the defense taken. And in case after case, we've had that particular experience. Finally, let me deal a little bit about the criminal activity, which was asked in the question. Now, in South Africa, we've now introduced Section 73, capital A of our Act, which does criminalize cartel activities. All my instincts, moral instincts, are, of course, people should go to jail. And of course, a few good cases of going off to prison would be a splendid idea and would concentrate the mind, particularly of people in industries where, as I indicated in my first opening point, those industries are servicing poor people. A bread cartel must be amongst one of the most pernicious activities you could imagine. What goes through the heads of people in a bread cartel scenario in a country like mine is beyond any form of rational or reasonable contemplation. The problem, however, is this: there are a series of problems. Firstly, from a perspective of a judge dealing with a competition case, where if you find a contravention of 4.1b, our hard cartel sort of provision, if I could put it that way, then of course that does trigger the significant possibility of a criminal activity. And one wonders whether we are now going to sort of look at this and say, well, it's not quite such a hard cartel, and therefore are we going to create a softer jurisprudence because we're anxious about the criminal consequences? That's number one. Secondly, I wonder what the criminalization effects may well have on our leniency program, and whether there won't be a battery of constitutional challenges to the sort of evidence produced in a leniency program, and what effectively the consequences of such evidence may be if it incriminates the party concerned. We've had that in the parallel cases of investigations under the Companies Act. It's possible. And so I'm a bit anxious about that. Thirdly, in order to actually have a serious intent for criminal activity, you're going to have a prosecuting authority that knows what it's doing and has a bit of competition expertise, or alternatively, one has to consider some umbrella organization in which the competition authority almost takes over that particular task, so that, in fact, competence is available in the prosecution. Therefore, to summarize, I'm not suggesting for one moment that there aren't compelling arguments as to why the criminal law should not be used. The problem is what effects it has, which are unforeseen on leniency, what effects they have on the jurisprudence of a court, which is now anxious about consequences beyond the strict adjudication of the cartel case, and thirdly, what capacity there is to prosecute these cases with the sort of accuracy and ferocity that is needed in order for criminal charges actually to be pinned upon people. Whatever the case, the fact is that's a debate one will have to have if you come to the criminal step. But far more important than that, seems to me, is that the better your leniency program and the greater the expertise of the adjudicators of the cartel activity, the more likely it is that you're going to have the sort of success which can then trigger off what I agree, which should be very high penalties. In answer to your point, Tembi, if I could conclude in this way, I really don't have sleepless nights about the administrative penalty. My own view is that once a cartel has been found to be a cartel, frankly, the penalty should be high. People know the consequences, and quite frankly, they have to face up to that because it has a massive deterrent effect. It's not so much retribution, but it's deterrence. And if we're going to allow slippage on that front, we'll reduce the force of deterrence. And that seems to me utterly crucial in this most pernicious form of anti-competitive activity. Thank you.